Morning. We have a majority of members present, and we've approved the agenda. And now we're going to have Steve Suo introduce our guests for today. Take it away, Steve.
Thanks, Todd. And thank all of you from the delegations from Kentucky and Oklahoma for joining us. We're really looking forward to hearing what you have to say. Just by way of general introduction, 3 weeks ago, we heard from experts on the federal FOIA law, particularly cost provisions that in effect have led the federal government to charge essentially nothing for public records from in the form of fees on requesters because of different classifications, a variety of reasons, but the law basically limits the amount that can be collected from requesters, and the feds essentially don't collect much of anything. I made contact with people in Kentucky and Oklahoma because those are two states that have their own restrictions on cost, what cost can be imposed on requesters. And you all can delve more deeply into this in your testimony, but generally from my culling of the Reporters Committee Open Government Guide, their description of the laws are that in Kentucky, generally non-commercial requesters may only be charged the cost of duplication of a record, not for the agency's staff time for search and redaction. And similarly, in Oklahoma, public bodies may recover only the cost of duplication for the most part. They can charge for search costs for commercial requesters or if a request would cause excessive disruption in gathering the documents. But crucially, the search costs still cannot be charged for news media requesters, scholars, and taxpayers whose request is in the public interest or the interest of government accountability generally. That's my reading of the RCFP's reading of those laws, and you all can correct any errors that I've made. So let me introduce the panelists. We have two guests from Kentucky. The first is Marcus Greene. He is a digital reporter for WDRB TV News in Louisville, Kentucky, excuse me, where he is part of a 7-member investigative unit. His work focuses on government accountability, transportation, and development. He spent 12 years at the Louisville Courier-Journal before joining WDRB in 2013. He routinely uses public records to shed light on Kentucky and Indiana agencies and has prevailed in numerous open records and open meetings disputes in both states. Melanie Lowe, also from Kentucky, is a graduate of Marshall University and the University of Kentucky College of Law. During her 18 years as a public defender with the Kentucky Department of Public Advocacy, Melanie routinely utilized open records in her legal practice and has regularly presented in educational forums for executive branch agencies, legislative bodies, and Kentucky's law schools. She has processed and litigated Kentucky open record
Steve, you're breaking up on me. I'm not sure if everybody else
is Kentucky
on that.
Can you hear me still?
No, we can't. Oh, no. No, not again.
You're frozen. Like you jumped off and to return again.
Can you hear me now?
Yes.
Yes.
Okay. I got to, I think I got to the end of Melanie's introduction concerning her service as records custodian with the Kentucky Department of Public Advocacy. Hopefully you all heard that. Lastly, Mark Thomas is Executive Vice President of the Oklahoma Press Association, the trade association of Oklahoma's 173 daily and weekly newspapers. He has been the Oklahoma Press Director for 26 years and was Executive Director of Colorado Press Association for 7 years. He has served on the board of the National Newspapers Association, is past president of the National Newspaper Association Managers, the Oklahoma Society of Association Executives, Freedom of Information Oklahoma, and is a member of the Oklahoma Journalism Hall of Fame. Mark was with Oklahoma Press in 1984 and 85 when Oklahoma's Open Records Act was first created, and he has worked on many of the changes to the Act since then. And I think what we'll do by way of format is we'll have our two Kentucky guests go first with some time after each person has spoken. We'll have some time for Q&A, and then we'll have Mark from Oklahoma go, and we'll have time for Q&A from him. I think it's a pretty informal group, so I hope our guests will entertain interruptions here and there if there are questions along the way. So with that, Marcus, welcome.
Well, thank you very much. I really appreciate the invitation from the subcommittee. It's a very important topic, and one that in Kentucky I've since learned we're very fortunate that we have a fee structure the way that it is. As it was mentioned, agencies in Kentucky are able to charge fees. They charge just for production of documents. And I'll be completely honest, it is rarely a calculation that we have to consider when deciding whether to pursue stories or even to make requests, because even a large number of pages is a relatively affordable request. And so a lot of times, in fact, I would say the overwhelming majority of times, cost is not a consideration. We have other issues that we have to deal with in terms of the way that Kentucky's Open Records Act is written and some of the hurdles that we typically come across, but cost is really one of them. And I would even say that in recent years, with the migration of many state agencies in particular to electronic records, we're not charged anything ever. Records are retrieved, copied, sent digitally, and provided free of charge. I have on occasion driven 30 miles to pay a literal dime for some agencies that would charge for a single page and refuse to send it electronically, but those days seem to be fewer and far between. So we're very fortunate in the fee structure that we have, and I can't speak for the agencies, but I know that in reading some of the materials that the committee has provided, a major concern from the public agency side is that changing the fee structure, making it more affordable for requesters could lead to fishing expeditions or reporters or other requesters who aren't taking the time to narrow their requests. And I would just say my experience in Kentucky, and I do work with some veteran reporters who have been doing this a long time, is that we will bend over backwards to try to really ensure that we're not putting public agencies into that type of position. We respect the time and the resources that they have, and a lot of that is relationship building that we've had over our careers. But I think there are ways to navigate some of these concerns. I'll defer to Melanie and others to talk about that. But from a reporter standpoint, I believe it really is a two-way street, and we're very fortunate that we have the law that we have. But I believe we make every effort not to abuse that, because it really doesn't serve anyone's interest to try to gum up the works. We recognize that public agencies are dealing with more than just reporters. They're also providing services to our friends and families. And I know that we make a concerted effort to try to respect their time and effort. And that's my elevator speech. I'd be happy to take any questions or elaborate on anything that you guys think is important.
I'll go ahead and jump in. Thank you for being here, Marcus. Could I ask a question? I'm just I'm on Muck Rock right now. I'm trying to understand, as I understand it, Kentucky's Open Records Act goes hand in hand with State Archives and Records Act. And I don't know if you have any background there, but something this group has batted around a lot is the idea that we need record management and maintenance, and that varies from public bodies across organs. Can you give us some background on how Kentucky cracked that nut?
Yeah, I would answer very truthfully in that I don't have a lot of experience in that arena, but I don't know if Melanie might. But a lot of the times the records that we're requesting are in active use, and so I really couldn't tell you, Tyler, how that works. I'm sorry.
No worries. Thank you.
I guess I'm moderating. So Todd, you're next.
Thanks, Steve. Thanks, Marcus. I appreciate your presentation. Did you say there's only one category of fees for production, or were there additional categories of fees as well?
The typical category of fees that I'm familiar with in my line of work is what's considered reasonable fees. That's what's written into the state law. And the reasonable fees, which are interpreted as 10 cents per page of a document, is for the production of that. So, for example, if I were to request, I'll use a recent example. I recently requested some inspection reports. We've had a series of deaths in the jail here in Louisville over the last 2 months. So what I did was requested the last 5 years worth of inspections that are done by the state. And that request came out to about 1,000 pages. Now, that agency could have charged me 10 cents per page, and that would have been, money that we'd have preferred not to have paid. But because it was done electronically, and because agencies a lot of times aren't charging for electronic documents, there was no charge. But there have been other examples of let's say a personnel file is a good example. In Kentucky, a lot of times public agencies haven't digitized personnel files. So if you're requesting that, those can be 30 pages, 100 pages, 500 pages, depending on a person's tenure. And so a 600 page, or let's say a 100-page report is something that you'd have to pay 10 cents per page for. But that's reasonable. I mean, that's something that I don't think most news organizations would oppose paying those fees. So yes, the fees are for production of documents. I've never been charged. We've never been charged, and we aren't charged for the time that an employee has spent digging out those documents and taking away from other duties that they may have.
Well, great. Well, then just a quick follow-up. So those production fees that exist, even though they're not commonly charged, is that a statewide fee schedule that binds state and local governments? And is it based on like hourly FTE of the employee doing it, or some other rate, if of like how they establish that amount?
Quite honestly, I believe it's just the generally accepted rate, and no one is really. I don't know if I necessarily would want this to be for them to want it to reconsider. But it's I've been doing this 22 years in Louisville, and it's pretty much the same rate that we've always been charged, 10 cents per page. It hasn't fluctuated or been adjusted. Melanie might know more about the history of that rate and how that's been set, but that's the generally acceptable rate that is charged when it's charged. And like I say, more often than not now, it's not charged.
Great, thank you. And Steve, I'll just say, if you haven't seen it, Emily put some questions in the chat.
Yeah, I was going to get to that, and I was going to say also, if any of our guests want to chime in on any question for another panelist, please, you're welcome, even if you don't yet have the floor. Emily asks, you just gave an example, Marcus, but what kinds of stories have you been able to do with public records that may have been hindered by cost otherwise?
That's a great question, and one that I've actually thought about, coming into this panel, because, on the one hand, while we do take every step to try to mitigate the work that's done by public agency, there are certain instances in which you can't do that. You're trying to be surgical, but you also have to make sure that you're not leaving anything out, especially when it comes to matters of public safety. I'll use an example. Years ago, following the Minneapolis I-35 collapse, many reporters across the country were looking at the structural integrity of bridges and overpasses in their area. And, that's not a story that you can do without accumulating lots of documents. In fact, I've got a file cabinet here that I've still got probably 3,000 pages of documents, inspection reports for all of those bridges. If there had been an onerous fee schedule for that request, I would imagine that a lot of that reporting wouldn't have been done. That we felt, and probably at the time would have paid that because of the interest of the motoring public. But there are other examples. I mean, I cover a relatively new project here in Kentucky. It's a multi-bridge toll network, all electronic, so there's no toll booths, and it's a very convoluted project run by the states of Kentucky and Indiana. And the way that it is set up, there's very little publicly required reporting, but there are many documents that are produced weekly and monthly that the agencies themselves, the transportation agencies themselves, receive. And so since the start of that project, I've been requesting on a bi-weekly basis pretty much every document that shows toll revenues, crossings, to ensure that it's meeting, you know, the projections, because there's a lot of public money and a lot of toll fees involved. And so we've done some pretty groundbreaking reporting that has actually led to changes in the way that the states oversee that project. It's helped to reduce the burden on the public. Again, we're talking hundreds of pages of documents on a regular basis that my bosses probably would have frowned upon me asking for at the outset before there were problems, because they would have asked me, well, why do we need this now? There's nothing that indicates that there's a problem. I did it as regular housekeeping to ensure that I could build my database. So, you know, there are examples of that. We have done extensive reporting on the Breonna Taylor shooting and the aftermath with Louisville police. Many of those stories would not have been possible because of the amount of documents produced from police investigative files. So just any number of stories that would not have been possible, or would have posed harder choices before pursuing, you know, if those fee schedules had been you know, higher in Kentucky, for sure.
You know, related to that, I'll ask Marcus. You know, in a case like Breonna Taylor or others where there's written narrative, I imagine you might see a lot of redactions, and is the process of redacting the documents, oftentimes, you know, in Oregon, that will entail potentially an attorney. Are those costs that agencies can charge you?
No, and again, back to, I think, the question that Tyler asked a few minutes ago. It's simply the production of the documents that we have the potential to be charged for. So, you know, there are other concerns and objections that we raise when documents are redacted, and when documents are even withheld because of provisions in Kentucky's open records law. But, you know, fortunately, again, the cost side of things doesn't really come into the equation.
Other questions for Marcus? Anybody outside of the PRAC who members of the public who have questions? Okay. Great. Well, I guess I'll ask one last question, Marcus. From what you know about Oregon's law, which I recognize is fairly limited, but I mean, your understanding of how fees work in Oregon, how well, if you just got hired at a company in Oregon, how do you think you would approach your job differently in doing records requests?
You know, I think in any state that has the type of fee schedule and related fees that I understand exist in Oregon, I think it would probably cause a lot more scrutiny of what records are being requested, and really asking the basic question: is this worth our time? Because, as you know, it's no great secret that news organizations not only these days are dealing with financial pressures that didn't exist years ago, but also staffing and resource pressures. And so, you know, everything is a trade-off. You know, knowing what I know about Oregon now and thinking about how we do our jobs here in Kentucky, I'm very thankful that a lot of those types of decisions aren't being we're not being forced to consider, you know, those types of decisions. But I do think, you know, a really important part of the conversation to be had, and I'd be happy to ask or answer any questions from any of the you know, the public agency folks, is to allay their concerns, because, you know, I like to think that I have a pretty good relationship with various records custodians at agencies here in Kentucky. We obviously always don't see eye to eye, and a lot of times, you know, they're denying me records and I'm challenging them. But, you know, I think a lot of the concern about what this could do to the workflow of agencies, there are ways to alleviate that, and a lot of it is relationships with the most common requesters, like attorneys or reporters. And that's not to say there aren't reporters who don't do their homework, and they'll send out voluminous requests that could easily have been narrowed down if they'd taken a few more minutes to really look at what they're asking for. But I think my main point is that there really is a balance that can be struck between minimizing the workload on the agencies and ensuring that the public gets the records without tremendous cost that is a deterrent to putting good information into the public realm.
Great, thank you. Mark, I saw your hand up for a minute. Do you question?
Well, I'm struggling because I'm interested in hearing from Melanie on this topic. You know, I'm struggling a little bit, Steve, and for everybody here, because when we last met, or it may have been the time before, I was hearing very clearly from folks, at least in Oregon, that the ability to charge fees was a very powerful and important tool in order to get people to narrow their requests. And what I'm hearing from Mr. Greene, and Mr. Greene, thank you very much for taking the time out of your day, and Mr. Thomas and Melanie as well. What I'm struggling with is the Kentucky model doesn't have what appears to me a tool to enable the custodians to get people to narrow their requests, right? And that to me sounds more like a trust me situation. I'm not sure that I'm at the trust falls place yet. Just for your background, Mr. Thomas, Greene, and Melanie, I'm sorry I didn't catch Melanie's last name. I'm a local government person, so I represent local governments. And so for my clients and for the people I represent, you know, I do believe that cost is a barrier to entry or barrier to access. I've said that before, but there's a balance that needs to be struck, in my opinion, at this point, that those custodians who receive requests for records need some ability to help requesters narrow those requests. And I'd be really interested in hearing from our guests today who don't, who come from states that don't charge for the effort to pull the records together, rather just for the actual copies, how that challenge is addressed. That's a very broad question. I'm going to have a follow-up question as well, which is about how the public interest is weighed, because if I heard at the beginning, it may have been it may have been Oklahoma, where if it is determined that it is in the public interest, the documents will be primarily provided or produced for free, except for potentially the hard copies that are produced. So I'm just curious to hear from our guests how that concern can be addressed. Thank you for your time. I apologize. I wasn't terribly articulate, but I'm having an internal conflict here, and I'm just curious about their take on that. Thank you very much, Steve.
Yeah, if I might, it is Oklahoma that has.
You froze
Thomas
on
can
us.
address when we get to that.
There we go.
Marcus, I don't know if you're in a position to speak to the balancing. We should hear more from Melanie. And I will add, I definitely think it would be helpful to have additional comment from the government perspective in each of these states. And I wouldn't rule out the possibility of having an additional panel down the road to do that. But I also think Melanie will have a really good perspective on it. So I'm eager to hear from her. But Marcus, do you want to take a crack at that question?
I mean, I actually am curious to hear what Melanie and others would say. So I'll defer to her, because I do think it's a very important question that Mark raises.
Yeah. Great. Well, why don't we then turn it over to Melanie Lowe from the Kentucky Department of Public Advocacy. Thank you for joining us, Melanie.
Thanks for having me. I appreciate it. Can you all hear me okay? Is my audio all right? Great. As Steve indicated, my name is Melanie Lowe. I'm currently General Counsel at the Kentucky Department of Public Advocacy. That is the statewide public defender agency in Kentucky. Our agency also administers federal disabilities rights advocacy. I've also been a legal counsel with the Kentucky State Police, and so I say that as a way of saying that I have two completely different ways of looking at public records in my work history as an attorney for state agencies. And I think that the culture of each agency kind of impacts a little bit how those are handed out. The public advocate, the person who's the commissioner of the agency I currently work for, he believes very strongly that public records should be public and that he wants to remove all hurdles possible. We have a very interactive process in our agency wherein we get a record that, request for a record that appears to be voluminous. And again, I don't know if it was clear or not when Marcus was talking about the statute, but our statute is broken down commercial versus non-commercial use as well. Just like you indicated, the Oklahoma statute sounds like it is. I'm not familiar with that statutory scheme, but that sounds consistent. It allows agencies to charge more for any that are commercially used, and certainly, a media requester would be considered commercial under our statutory scheme. With regard to requesters, we get a lot of requests from people that end up being voluminous. We usually take an opportunity to reach out to the requester and try to help them narrow down what they're looking for. A lot of times that involves talking to a reporter like Marcus to say, what is it you're trying to get at here and how can we help you narrow down the scope of your request? I don't think that requesters want to be difficult, generally speaking, although certainly when I was at the state police, we had a local watchdog individual who ran a website who wanted to ask for lots and lots of records about lots and lots of things. And so it was difficult to get him to narrow things down. I think generally speaking, people want to narrow them down so that they're not inundated with what they're not looking for. And I don't think that cost is the way that is certainly one way to do that. In 2021, the Kentucky legislature actually narrowed our statute to include, to preclude requests from people who are outside the state, who don't have contacts with the state of Kentucky. So there is a residency requirement. Additionally, and that includes businesses with contacts in Kentucky. So any media organizations in Kentucky can make those requests. What we've seen since last year, and again, that's relatively new, that most of the commercial requesters can come up with a local person to request it, whether it's a local affiliate. But I do think that keeps us from getting, and in my agency and with the state police, we sometimes would get what I would describe as fringe individuals who are looking to find things and want to make requests out of state. We received a lot from a gentleman in Michigan earlier this year. And we just contact that person and do our best to try to narrow down what they're looking for. And I would say probably 10% or less are people that are difficult to deal with on the issue of narrowing it down, probably considerably less than that for the most part. People really only want you to give them what they're looking for, and understanding what the records are in the format that they're kept in. I would also agree with Marcus that the move toward electronic records has been a big cost saver for agencies. Our open records law dates back to 1992. Most of the sections were updated in 1994. That addition that was added as a residency requirement was relatively new, and that was just last year. There were a few additional changes made to the law. So I think that we're moving toward an electronic format, and that has made it much easier for from a cost perspective. I don't know if that's helpful or not. It's a lot of times what we're doing is compiling, if we have the actual record, we're running it through the scanner and putting it onto a flash drive. The cost of electronic storage has gone down so much that we almost never charge anyone for that, even the media, just because it's very easy to provide those records. I would also say that the last two gubernatorial administrations in Kentucky have pushed for open records to be available to everyone. The last governor wanted a portal in which records could be compiled by agencies to prevent agencies from having to provide records under those. So things that are requested over and over again, there's actually an electronic portal. I think that's still, they're still working on getting that in a way that it is a meaningful cost reducer for state agencies and local agencies. But that portal means that, you know, the agency can then say, hey, you can access these records yourself on this portal. I don't know that the newest administration, the current administration, has done a lot to expand what's available to requesters on that website, but I do think that is a cost savings that I think more states that are cost averse like Kentucky will be likely to do more of in the future. The current administration requires every single agency to have a portal in which an electronic request can be made, and we're required to provide those records, and we can do that by email, and that even further reduces costs like postage that are built into our statute. There are a few agencies, and I would say that the Kentucky State Police, whenever I worked there, they had a very high volume of open records requests that, and I do think that they are one of the more difficult agencies to get records from. And so they sort of had a perspective of deny first, then we'll fight it out later. In Kentucky, ours are appealed to the Attorney General's office, and then there's an appellate process with the circuit court in Franklin County, where our state capital is, and judges there routinely deal with open records issues. And our judges have been very, very liberal in trying to keep regular people from having costs related to open records, and the Kentucky State Police in particular has had several rulings against them that have included damages and requiring to provide costs back to people for getting records in other manners through those lawsuits in state court. So I do think that those have all contributed to that. The things that Marcus has indicated, where in Kentucky, I don't know, I guess maybe I thought it was sort of Southern hospitality at play, but I think it's just easier as a state agency to make an electronic copy of things and to send that stuff out and to get that done, than it becomes to have to deal with the appeal process through the Attorney General's office and the possible pro se litigation, or even litigation by professional attorneys at the state court level. So it is just, for us, it has been a cost savings, and being able to confer with people who are requesting records has always been a way to try to keep costs down as well. I think probably answering the questions that you all have might be the easiest way to use the time that you guys have for me.
Mark, you can speak up again if you'd like, but I was just going to redirect that question to you, that Melanie, like what levers does a public body have, if not fees, to make sure that a requester, you know, comes to the table and behaves reasonably?
Well, I think that I don't know, maybe it is a bigger problem in Oregon than it is in Kentucky. We just don't really have, I mean, there are certainly fringe individuals, and our statute is replete with ways to deny requests. And I think some agencies have been maybe more, maybe they are a little more creative with how they use those exemptions for people that are particularly difficult, for parties that are maybe more fringe and asking and unwilling to work with you. The other issue is our statute requires a response within 5 days to let the requester know. I don't know how your roles is set up, but then we're just required to let them know how long it's going to take us to get those records ready. And there isn't a time set up in the statute to require us to respond. And so it can be done in, you know, for very large records, we can have our open records person be working on things at multiple times, setting that aside, and it keeps from having to make it such a burden on on our agency. I think every agency in Kentucky state government has an open records person. At the Kentucky State Police, we had an actual paralegal who assisted with responding to those requests. In my agency, I'm the official records custodian, and I oversee our open records clerk, who pulls those from, as you all mentioned, our state archive, as well as within the agency. We have offices throughout the state of Kentucky, and so often requests that come in, we'll need to pull those records from different locations throughout the state in order to get those to the requester in compliance with the statute.
I think Mark first, and then Tyler.
Yeah, Steve, Ms. Lowe, I'm curious about, you mentioned that that Kentucky has exemptions to address some of these problematic requesters. Can you share with us what those exemptions are? And the reason I ask this is, in Oregon, we have sort of a trifurcated, if that's even a word, system whereby there are some records that are explicitly exempt from disclosure. There are some records that have a public interest weight to it. And then there are those records that are open to the public, right? My question to you is, you mentioned these exemptions. Are you talking about exemptions for specific sensitive information, or are there broad categories of exemptions whereby you can deny a requester because of, you fill in the blank?
Sure.
Help me understand that, if you could, please. Thank you.
Sure. So our statute, probably not surprisingly, it seems like the state legislatures, maybe ours is special, doesn't tend to make things terribly simple. So our series of exemptions have evolved since '92, and things have been added over the years. The most recent additions included actually the client files from my particular agency. So it's not that anyone could ever access a client file other than the individual who owned the file, the client. But we still had to, it was required for us to provide it under the statute to the individual client as an open record. And so obviously, if we have a client that asks for a file, we have an ethical duty to provide that client with the file. But that was one of the more recent additions. But most of them are pretty specific, but a lot of them are things like, if there's an investigation in place, and that includes adjudicative bodies as well as law enforcement, until that, or if an agency decision is pending, they are exempted from providing the investigation leading up to that agency decision. They can get the final decision or policy that arises from that, but not necessarily the full investigation as it's related to that. So there are a variety of those exemptions in the statute that agencies can claim. They can say, this is not a final action, therefore it's not available, or this was part of a preliminary investigation, and so it's not appropriate. There's also an exemption for individuals for the release of information that a person might deem to be too personal, or be likely to cause that person personal harm. The other one that comes to mind in particular with that, it can't be, you can deny a request based on an individual who is making repeated requests in a harassing or a way to disrupt your business. So that you can deny it on that, and I think the state courts have been very, very good to agencies in allowing that. I could send you the specific language from our statute that defines that, but essentially, I've had that maybe once since I've been general counsel of this agency. And they tried to define the watchdog gentleman with the state police to be that kind of person, but he really was using these records to put out to the public on a website, trying to keep track of police organization and the police activities in his community. And so the court actually denied that, but that was one of the reasons that the state police had denied some of his requests that were voluminous. And so what we found as an agency is that it's much easier to communicate with the requester, try to narrow down the request. And then if you're getting repeated requests, there is a section under the statute to say that this person is attempting to harass the agency or disrupt our business. And so we can deny it based on that. They can then seek to appeal that to the Attorney General's office and then again in state court.
Thank you for that, Ms. Lowe. I think it would be helpful for us to, if you wouldn't mind, forwarding that language to our group. Again, most of my interest on this topic about having a tool to narrow people's requests is largely centered on the type of frequent flyers that may be categorized as harassment, if you will. And I'm relieved to hear that there is a relief valve, if you will, at least in Kentucky. So thank you very much for that information. I appreciate it.
Sure. And I'll pull that entire statute and just put it into an email and highlight the relevant portion that applies to that exemption. Sure.
Tyler, you have a question.
Yes. Thanks for the presentation, Melanie. I'm just trying to suss out, and I'm here on behalf of counties today. You know, what I'm thinking of is the small county, a person who might wear multiple hats, do records as part of their job, but they're not sitting, you know, all day, every day waiting for a request to float in. So I'm wondering if you can just offer any commentary. Are there challenges that you're experiencing? I'm trying to piece together by, you know, doing some Googling as you're looking. I'm looking at Kentucky's open records laws. I see that I'm really fascinated by this concept of better records maintenance leading to better records results at the requesting side. I think that's the, you know, we've batted that around in this group a lot as a goal. But can you speak at all to what that experience is like in getting a record from a small local government?
Sure.
And do they have assistance from the state?
So I think essentially, no, they don't have assistance from the state as you would define it at any financial support or additional support from the state, except in those instances in which the state is maintaining the records compiled by the counties. So I think that, you know, Department of Transportation would be an example. You know, in my case practice, I had a homicide case when I was a public defender that involved a stretch of road where everybody in the county knew that this was a place that there were a lot of accidents. And so we made a request to the state and the county who maintained that stretch of road as to whether there had been any communication to do a safety study or anything else. Most of the counties and local governments have an attorney staff. So our cities have city attorneys, our counties have county attorneys, and they're well versed. There's a lot of education in Kentucky for county attorneys and agency attorneys to go to open records training with the state. So I think the state does provide that angle of support and help train them on how to pull the records, what the law requires, and to make sure that they're on the side of providing the records when they can. I don't see, I know that there can be times in which records are very obstructive to the operations of counties and cities. And I know anecdotally that happens, but I just, from my perspective, having done lots of requests as an attorney and as a person who's responded to them, it hasn't become a big issue. Most agencies have a records clerk who also does records, open records, and they've been to the training. They know what the training is, and they know to consult with the attorney advisor appropriate for their organization to get information about how best to comply with it. I do think that the collaborative process that we use with our requesters is really helpful to narrowing things down and to keeping the burden off of those individual clerks who are the ones that are bearing the brunt of that. We also, when we get big projects, we have an open records clerk, but then we have secretarial staff or administrative staff whose job it is to try to help us redact things that need to be redacted. And then that it's done as a process of this is how long it takes. And once we've been doing it for a while, I now have a good idea of, I have an investigative report that's 200 pages that's been requested by a local newspaper. I know how long it's going to take my staff to get that done based on our other workflow. And I think that it ends up just being part of the background noise of running your agency, your organization, your county, your city. And I don't see it as a real hindrance, although I do think, to be fair with the state police, they did see it as a to their regular business. They did see that they got a lot of, and at that time they were getting a lot of record requests from out of state people. So I do think that state resident requirement that was adopted maybe will help somewhat. I do think that people who are fringe or unhinged or mentally ill may tend to make those requests to police agencies before, say, a Department of Public Advocacy. So.
And if I could jump in and just add very quickly, one of the reasons why Kentucky amended its open records law in 2019 to have the residency requirement was because some of the local governments, cities in particular, were complaining about these requests. And I know I went back and looked at a story that we had done where in some of these small cities, the majority of their open records requests were coming from out-of-state entities and requesters. So, I would think that probably was a way to alleviate that burden on cities and counties. Again, Kentucky has 120 counties, so we're talking in many cases. I know I've talked to records custodians in counties and cities before who may get one every 6 months. So I don't know how common it is. I know Oregon, I believe, I know it has fewer counties than Kentucky. So I know it's probably, a bigger issue in your state than it is in ours.
I did locate that language in the statute. So the language that we have, and again, I'll still provide it by email, but if the application of the open records law places an unreasonable burden in producing, or if the custodian has reason to believe that repeated requests are intended to disrupt other essential functions of the public agency, the official custodian may refuse to permit inspection of the public record or mail copies thereof. However, refusal under this section shall be sustained by clear and convincing evidence. So that's the evidentiary standard that's applied by our Attorney General's office, who receives appeals, as well as the state courts.
That's very interesting. Todd, you've had your hand up. You're muted.
Sorry, it had to happen at least once. Hey, Melanie, thanks for your presentation. I believe I heard you say that members of the media are treated as commercial requesters. Is that true?
That's correct. Yep.
That's not the model in Oregon, and just one I'm not familiar with. Can you just talk to us a little bit more about that? Is that in statute? How discretionary is it? I heard Marcus say that as a member of the media, he rarely pays, but commercial requesters are generally charged full freight. So how does that all kind of work out?
With regard to our statute, the commercial section still keeps costs pretty low. So it divides requesters into commercial and non-commercial. And the things that individual agencies are allowed to charge for is the media utilized, the processing. So the actual, what that has been boiled down to, and again, it's been this way for as long as I've been in state government. So it's been 10 cents per page. That's the cost that somebody adopted at some point. Everybody said that's what everybody else was doing, and that seems to be the general rule across across all the agencies in state government. But it's media processing and staff, and if they're asking for the records in a format that is different than how the records are stored, then they can actually make an additional fee for changing the format of how the records are kept or how they're reproduced. In my experience, that just has not come up. I think whenever I was at the state police, we had a media requester who wanted schematics of the system of security that was installed under state police supervision at the governor's mansion. And so there were other exemptions for us to utilize to deny that request, rather than actually sending these huge schematics of the governor's mansion. So I haven't had that come up, but I think that the general rule is that it's because everything's kept in electronic format in large part by most of these agencies, or can be easily converted into a PDF format. It just hasn't come up that we've gotten huge amounts that have been very expensive to produce, because we have somebody on staff that regularly does that work. And our open records clerk is also handles all file requests from all of our clients, and we represent 3/4 of the defendants in criminal court throughout the state of Kentucky. So that's a good portion of his job, but he also does open records for the agency. And because we have an electronic database which compiles lots of criminal information about clients and cases and how cases are disposed of to show impact of laws on clients, we get a lot of requests from media about those records. And so those are reports that we can pull, and there's just not a cost associated with that. I don't know if that answered your question in any way. If you want to follow up, I'm happy to try better.
Well, actually, you did say one thing I wanted to follow up on quickly, which is that most things are electronic or easily converted. Is that a state mandate? Is that supported from on high? Is there funding for it? How did that come about in Kentucky? Because here, a lot of our stuff is not electronic right now at the state or local level, for sure.
Well, when we get large requests, and we have to pull, boxes and boxes of files from the state archive, obviously converting everything, our files as an agency for clients are put into a file retention system that's electronic. Most of the time, we also have a file that's in paper as well. But I think each agency is trying to convert that way because of the very low cost associated with that. Now, there is a cost shifting there, because storing those records in electronic format does create some storage issues for agencies. But I do feel like that the legislature, that the state does provide good funding, and funding requests can be made through our finance cabinet to get assistance with storage for electronic files. So I think that's really done at the agency level to convert those. And when we get boxes of files, or we have particular things that are requested, converting those to a PDF through a printer is really all I mean by converting. Scanning those records, and then often we retain a copy of those in electronic format in addition to sending that back to the archives. And then if we get a follow-up request, we have that already at the ready, and it's much easier to provide.
I have a question, if I may, Melanie. Did I understand you correctly that in the agencies you work in, there are dedicated staff whose job is strictly to do public records requests?
No, I wouldn't say that. So we have people who part of their job is open records requests. So whenever I was with the Kentucky State Police, there was a paralegal who did lots of other roles in addition to open records, but that was a portion of her job. And so from time to time, she would have to be careful about her scheduling in order to be able to fulfill an open records request that came in that was large. In my current agency, we have an open records clerk. The vast majority of his job is providing clients with copies of files. We have clients who are in custody who want to receive a copy of their file, and maybe it was a serious case that has 10 banker boxes. And so his job is to produce those and mail those out to the clients. That's an ethical duty that we have, although, as I indicated, it was 2 layers with open records being interpreted to include those files until the most recent change in the law. But yet a portion of his job is just to respond to open records requests. Those are all received by me as the custodian of all records. And then I delegate that task to him to get those from archives or to locate those from the individual office, have those scanned in to our system.
Yeah. Well, I may ask you to speculate just a bit or offer an opinion. Do you, when you were talking about the use of electronic records in Kentucky, it made me wonder whether whether the lack of an ability to recoup costs has offered an incentive for public bodies to improve their records retention procedures, because they're going to have to eat the cost of doing the search. They keep things, more efficiently.
Well, attorneys love to speculate. That's our favorite thing, right? To opine and to speculate. So I'm happy to do it, and I do think that that's part of it. I do think that all of our state agencies and local government entities have responded to this culture of very low cost for the requester by making it as easy as possible to be able to get those records and to get them efficiently to the requester. Because I think the higher cost for us, at least in Kentucky, is the cost of litigating those things. The response to the Attorney General's office, the Attorney General can assess fines and fees if we do not comply with open records. And if it goes to the court, then you're paying either a private attorney because you've had to contract with somebody or your local counsel, and that's time is money for that as well. So I do think that the litigation costs, the appeal costs of denying requesters has developed a culture in most of our agencies in which we collaborate with the requester to try to get them what they're looking for, try to assist them in finding what they need, and do that in the most efficient way possible. And converting our records into an electronic format has been a good way to do that.
Great, thank you. Who else has questions for Melanie? Anybody on the call from the public? Others who would like to ask a question? Oh, okay, question from Emily, our chair. Wait, let me read that again. Do you know how many times agencies have denied requesters based on harassment grounds?
I would say it's probably significant. I don't think that agencies lean on that as a primary. That's usually going to be for somebody who's repeatedly requesting the same kinds of records or crossovers of records or records that have already been provided or records that they have been told or do not exist or cannot be provided to them for one of the other exemptions. So I think typically it's kind of like the first bite rule with a dog bite, right? Your dog gets a first bite. So every requester gets that first opportunity to make that request. And then if subsequent requests are requesting for the same things that they've been told are unavailable, or things that have already been provided, or things that they've told them that this particular agency is not the custodian of those records, so you cannot request it from us, then I think it's used pretty frequently and has been, I believe, upheld by both the Attorney General. But we have to show, but it's still a pretty low standard of proof for us to demonstrate that this person, I've responded to these requests before, these appeals of these requests where we've utilized that. And so typically what that requires is that, we keep a file on anyone that makes repeated requests. And so all of our communication goes into that file, and we just attach that to our response to the Attorney General to demonstrate we told them that we didn't have these records, or we told them that they needed to seek these records from a different agency. And so that's been upheld primarily. I think most of the time when that's been used, it's mostly been individuals, often individuals who maybe have a different perception of reality. And so those people seem to be the people who are less likely to go through the appeal process, and less likely to win at the appeal process, and definitely less likely to undertake an appeal with the state court. And so while I think that the Attorney General's process is fairly pro se friendly, that's still, there's a certain amount of checking the boxes that have to be done in order for those appeals to be perfected with the Attorney General. So I think that has by and large, that appeal process has kept those at bay. But I do think it's used quite a bit with repeat requesters.
Great. I hate to impose on you further, Melanie, but it makes me think it would be great to be able to see maybe a few examples of cases where that's been employed and it's been upheld by the courts. I don't know whether that's, would we ask, is the Attorney General the best place to look for that, or would you have examples from your agency that you could offer?
I could see if I can find one of those recent ones. Honestly, names are not my strong suit after 22 years in state government representing thousands of clients. Names are not something that stick in my head any longer, but the Attorney General's website in Kentucky does have an open records page and does list, they publish their opinions on there. So I'll look and see what I can find in my records, but also I'll look on the Attorney General's website and see if I can see some examples where that's been upheld, and maybe see if I can find one out of the state court as well.
Terrific. Thank you so much.
Sure.
Other questions for Melanie before we turn to Mark Thomas? Okay. I should say, I don't know if we'll go past the next half hour, but Marcus Greene has another obligation. He'll need to leave us in about 25 minutes. Thank you for joining and sticking with the discussion, Marcus. With that, I think let's turn it over to Mark Thomas. Thanks for being patient, and tell us how it works in Oklahoma.
Okay, Steve, thank you. Can you hear me all right? Is everything fine? Well, in Oklahoma, I'll just say that, and I enjoy participating in these and talking about it because I always learn as much as I'm able to give. So I appreciate what you've said about Kentucky and what Kentucky has said, what Oregon does as well, because I think we're all trying to reach the pinnacle of who's best that helps the public and the public bodies. I've been here a long time, and I remember back in 1984, 85, when we were working on this, we kind of started, to be honest with you, with the old Declaration of Independence. We kind of forget that when the founding fathers wrote the king and said, we're leaving you, and it's incumbent on us to tell you why we're leaving you. Reason number 4 was, you don't give us access to our public records so we can defend ourselves against you. And number 10 was the 10th injury of the colonists was you set up all of this bureaucracy to harass the people and eat out their substance. So from that point forward, we've tried to say, you know, let's do what we can not to have a bureaucracy. Let's do what we can not to not try and frustrate people when they're trying to access their public records. So that's kind of where we started back in 85. We didn't want to have a revolutionary war on our hands here in the small state of Oklahoma. The policy statement in the state of Oklahoma basically says it's the inherent right to know and be fully informed about your government. And that's kind of the place that we start. And in Oklahoma, there's really 2 ways to look at it, to go back to what Mark Landauer was said when he was saying there were 3 kinds of ways. We really look at it in 2 ways. Our policy is set up that says all records are open unless a law closes them down, with the exception of law enforcement. All law enforcement records are essentially closed unless a law opens them up. So in other words, if you're a public body and you want a record closed, you've got to go to the government and say, we need it closed, and here's why we need it closed. And there are a lot of valid reasons for that, and we can generally negotiate those out. If it's law enforcement, there's a long list of things that law enforcement is required to give, and if I think law enforcement should be required to give more, I've got to go to the legislature and convince them that I will not be hurting law enforcement if they reveal this record. So that's really the way our structure is here in Oklahoma in terms of the records. It's certainly not perfect. We have a working group coming this summer and fall to try and work on some of these same things we've been talking about. And I will say at the outset that even from 1984, 85 up until the present day, we have never figured out what to do about the nuts. So let's just get that clear. Sometimes the nuts are, sometimes they're reporters, sometimes they're city councilmen, sometimes they're private citizens. But how do you wrangle some of these things? I think we've I think Melanie called them fringe or unhinged or something. That's just a problem we've had all along, and it does come back a lot of times to the excessive request situation. But Oklahoma law is a little bit different in that our law allows for inspection and copying, okay, and mechanical reproduction. In other words, I get to see a record, and then if I want a copy, I pay for it. It's 25 cents a page, $1 a page for a certified copy. And then we do have the commercial purpose, but if you're doing it for a commercial purpose, you would have to pay search fees and some of the direct cost of copying and mechanical reproduction. And our Attorney General has looked at that and said, what is the direct cost? He did an Attorney General's opinion. The direct cost was essentially, the cost of whatever medium it is, whether it's paper or whether it's electronic, the search and the processing necessary of that search, as well as a piece of the labor that is directly attributable to fulfilling that request. So commercial enterprises do end up paying more than non-commercial purposes, and those non-commercial purposes are defined really in three ways. And this goes back to, I think, the question that Mark Landauer had. Our three ways are the news media for news purposes. That's an important phrase, by the way, because some news media companies own digital marketing firms or they own database firms. And if you're using it for journalism, you shouldn't be having to pay. But if you're using it for news purposes, but if you're using it as a commercial enterprise, you should pay that commercial fee. The news media for news purposes is determined not to be a commercial purpose. Second one, it says it's when scholars and authors and other people who are in the public interest. That I agree is a very fuzzy phrase that sometimes has to be argued out, and if it can't be agreed to by the persons, you end up having to go to court. Is this record in the public interest or not? And the third phrase that's really it's used a little bit and it causes some concern, the phrase we have in the law that you're not a commercial purpose if you are a citizen who is a taxpayer, it says, by the way, taxpayer who is trying to determine whether a public servant is faithfully, competently, and honestly executing their duties. So you're not a commercial enterprise if you're just that kind of a person. A lot of times that's where some of the fringe requests come in, and they make excessive requests. But like I said, this all started when we started in 1985 and had the first law. There was no schedule of fees. It just said public bodies can set their own fees. That lasted for about 18 months when the schedule of set fees turned out to be all over the place. And in fact, some were using it essentially as a way to fund their entire office, was by being the sole custodian of the public records. So we had to rein that back in and say, let's set some fees in the statute. And so that was done really in 1987. Like I said, 25 cents a page and $1 a page for certified copy, then the commercial purpose and so forth. They also added in 1987 the language that said that the fees that were set by the public bodies shall not be used for the purpose of discouraging requests for information or as obstacles to disclosure of information. And that is a phrase that sometimes you're able to look and say you're just charging a certain fee. And I find it most often when some small public body somewhere says, we're going to have our attorney as our records custodian. They're going to look at every request, even if it's a simple one-page thing, and we'll look at it. He'll look at it for a few hours and he'll charge you a lot of money for that. That's sometimes where you see that they're charging fees to just discourage you from asking for that. It's not as big a problem for the media because we're not a commercial purpose, but it is for private citizens sometimes who are asking for that information. You asked, I think, and I kind of want to go to Mark Landauer's question about excessive requests. We have that same language. Well, let me rephrase that. We have language that says that the public bodies can protect the integrity of their records and prevent the disruption of their essential function and excessive records requests. But we do not have the language that Kentucky has, and frankly don't agree with it, that says if the records custodian has reason to believe it is excessive, they will just deny your request. If you're making a request that's excessive, our standard here, we don't have a 5-day standard or a 10-day standard or what. Our standard is a lot, is more vague. Our standard for records request is you must provide prompt and reasonable access to your records. If you make an excessive request, it should reasonably take an excessive amount of time to fulfill your request. To go back to Mark's point, how do you limit requests? Well, I don't know that we limit requests here, but if you make an excessive request, it may take you 1.5 years to get those records. So I'll give them to you 5 records every Friday because I'm working on other records requests as well. So the prompt and reasonable standard, while it is fuzzy, gives the public body the flexibility to address records requests as they come in. And that has worked for quite a few years. However, it worked in a time when we felt like reasonable people could agree on what reasonable was. We may have passed that point. I'm not sure what the inflection point of where we missed that, but I feel like we maybe in this summer and fall, we're talking about excessive requests and what to do about that and how do you do about that. We'll also talk about a residency requirement, although we do not have one right now, because we felt it would just set up an Oklahoma cottage industry that Mark Thomas at the Press Association would become the out-of-state records request service. And I would request all your records for you, upcharge, and sell you the records. So we don't have any kind of residency requirement here.
Mark, I'm sorry, may I just interrupt briefly? Tyler Jansen has a question for you.
Yeah, Tyler.
Yes, hi, thanks, Mark. So my question is, if I just understood you correctly, it's in the eye of the beholder, the custodian, what constitutes an excessive disruption. Is there any sort of appeals process if a requester asks a public body and the response that they get is, sorry, that's an excessive disruption? Does that requester have any recourse after that?
That the requester, there is no process like they have in Kentucky where there's an ombudsman or someone at the Attorney General's office designated to adjudicate that issue. We do not have that kind of office here. We've talked about it several times. We've been trying to figure out where we would house such a person, but we do not have. It's basically a court process where if you don't feel like it's an excessive request and you're being denied, you can always go to court and you may lose, and you would have to pay the fees of the public body. If you win, they would have to pay your attorney's fees as well. So that's really the incentive to sort of work that out. but I will admit there is an increasing level of frustration on both sides that we do not have a better definition of excessive or a more streamlined records request process. That's why we're meeting this summer and fall to try and work out some of those things. Our law also says that the public bodies, it says they shall designate certain persons who are authorized to release records of the public body. So there's supposed to be somebody there at all times during regular business hours that the office is open to go get a record, find it, make you a copy, process your request. And that was not in the law before. I mean, you would go to a public, there would be nobody there to process your request if you had one. So our law basically puts it on the public body and says it's part of your function as a government agency to have someone available to give us records when we ask for them. During the regular business hours of the body. And we have a couple of exceptions there. We have, I think Mark works for Special Districts Association, so small political subdivisions. So we have, they may have a clerk that works 10 hours a week and the records are in their home in some rural water district. So our law kind of addresses how do you structure that? How do you make those kind of requests? But there's no more of this problem where you go and ask for a record and they say, well, the sheriff is gone. He's the only one that can request that. He'll be back in a week. We'll let you know. Somebody's supposed to be there to get you a copy of that police report. And by the way, when it says regular business hours, I think we've come to pretty good agreements with law enforcement, particularly, that they can set hours during the day because, the truth is the police station's open 24 hours a day. They're open, but those are not the hours that are their regular business hours. So I think if you're a records requester for law enforcement, you have to know what their regular hours are. You can't go at 2 a.m. and say, the law says you have to have a person here to get me a record. So they're able to set what their business hours are. So we have worked through that kind of flexibility for people that are open 24 hours and people that are only open 10 hours. Okay. So, anyway, that's kind of how we've dealt with that and how we've dealt with the massive requests. You can't really deny their request, but you should expect your request to take a massive amount of time. So that is the incentive to not make a massive request. You're not going to get it for a long time. You should tailor your request to what you think you're wanting and try and work it out. As Melanie said, if a lot of times I request records in my language, but the public official thinks of it in a different way and they don't recognize what I'm asking for. So some line of communication is always helpful. It has helped a lot to put a lot of public records online. And in fact, we've incentivized, I think, the public bodies to say, for any records you put online, you cannot be sued for not providing prompt, reasonable access when it's all there online. That's your incentive. I mean, if you don't want to put them online and you want someone to come to your office and make a request and wait for it, and you wait a week or 2 or 3 and it shouldn't take that long, you can sue and you may win. But why take a chance? Go ahead and put them online if they're available, and you can avoid any prompt, reasonable legal action by putting them online. So that's been kind of an incentive for them. I see Mark Landauer's hand is up, so if he wants to jump in, I'd be glad to take it.
Thank you. Mr. Thomas, thank you again for being here. I do have a question, and it's probably sort of two-part. You had talked previously about the commercial exemptions, one being citizens who are looking into political figures to see whether or not they're conducting their responsibilities honorably or honestly or lawfully or what have you. My question to you goes back to something Steve said at the outset, that if I understood him correctly, that there's a strong public interest determination in Oklahoma, and if there is a public interest that is determined as surrounding the release of information, generally that information is provided at no cost to citizens. Did I understand that correctly?
No,
Okay.
okay. If you're talking about Kentucky, maybe so, but in Oklahoma, if I'm just a taxpayer seeking whether you're faithfully, honestly, competently doing your duties, I can request those records, and I would still have to pay for the cost of those records. I still have to pay 25 cents a page, $1 a page, whatever it is. I still have to pay for the records, but you can't be charging me a search fee. So they still pay for the cost of those records. So if they make a massive request, you can charge them a massive amount and take a long time to do it, but they should narrow their request. But commercial firms, you could.
Thank you for that clarification. I appreciate it. I don't have any follow-up.
Mark, Thomas, I have I think a related question. So the going back to excessive disruption, can that be applied to news media or not? Are news media basically carved out?
Well, you got to remember our definition of excessive disruption is that they can protect against their office and their files and their procedures from excessive disruption. They can't deny you records even though it's a large request. Whether it's excessive or not is not really defined in Oklahoma law. But if it's a large request, you need to start filling it, but it may take a long time. Okay, and that happens a lot, and that's kind of how they do you see what I'm saying?
Yeah.
In Kentucky, they just say we have reason to believe your request is excessive, denied. That's standard was not okay for us, where it was totally in the eye of the custodian of the record, whether it was excessive or not. And so we've not gone with that Kentucky standard. I think Kansas has it too. Those may be the only two states that I know of that have that reason to believe standard.
I'm sorry, I was going based on this description by the Reporters Committee on Freedom of the Press, where it says, for Oklahoma, if a request is made solely for a commercial purpose or would cause excessive disruption in gathering the documents, the public body can charge search fees. Yeah. But then in the next sentence, however, search fees cannot be imposed on the news media, scholars, etc.
Right. So the news media would still have to pay for the copies and so forth like that, but they would not have to pay for a search fee.
But you could charge a fee for search for a commercial requester.
Yes, you can.
If it's disruptive, or anybody other than the news media or scholar, if it's going to be disruptive.
Yeah, anything that's a commercial, kind of a commercial purpose. And we did that originally, I mean, as a protection for the public bodies. I mean, they needed a way to here we still have abstracts for property here, an abstracted state. The abstractors would come in and make massive requests and would and expect, and here's where the disruption. They would expect you to stop everything you're doing and fulfill their request. Now, I'm sorry, that's not how that works. We'll put your request in and we'll start working on it, but we're not going to stop. It it's going to disrupt our essential function because it's an excessive request. And we really felt like that was improper for people to do that. So, I mean, and they also have the ability to protect the integrity of their records, which was important. So I will say, and I don't want to get too far off track, but we tried really hard to help records custodians, give them some tools to work through these excessive requests. One thing I do want to point out is about 3 years ago, we had a bit of a issue with our former governor, who decided that all records requests coming to her office would be first in, first out requests, which seems logical in many circumstances. Fast food restaurant, first in, first out. I get it. But what the governor's office did, the lady who did the records request, received the request, basically had a friend come and make a massive request, which was going to take a year to fill. And the second request was a one-page document for the governor's schedule tomorrow. Sorry, your one-page document is behind this massive request. First in, first out. So we had to wade into the law and say, you can't really do a first in, first out policy, because that enables an abuser to have a massive request made just to forestall all other requests. So you kind of have to work on them all, for lack of a better word, simultaneously, or at least get the ones out that you can get out. And if you make a massive request, you kind of suffer the consequences of it not being fulfilled for a long time. So that's kind of was a problem we had to deal with just in the last 3 years.
Hey, Mark, I'm sorry, I'm going to interrupt one more time just because there's some questions in the chat that I want to get to from Emily, our chair. And also she posed this to both you and Melanie. So if Melanie's still here, she can speak to it. She says, we heard from Margaret Quokka, author of a new book on the federal FOIA, in an earlier session. She found that the media made only about 3% of federal FOIA requests. Do you know who does, I think what she's saying is, do you know what percentage of public records requests are from the media in Oklahoma and in Kentucky?
I do not know. Yeah, Melanie?
I don't know off the top of my head. With the two agencies that I've worked for, I would say it is probably less than 10%. And probably that sounds correct to me, given the volume that we receive. That's probably erring on the side of caution a little too much, but I would say probably somewhere between 8 and 10%.
Yeah.
So state police, it's often attorneys and stuff like that, or
right, attorneys,
on behalf.
Citizens. Yes, correct.
Right, and I would say probably so. And it's like Marcus said, a lot of the news media has a vested interest in filing a specific request and getting what they want so they can get on with it. And they have an ongoing relationship with the clerk, with whom they have great respect for the difficulty of being a clerk at a county level or a city level or a school. I mean, there's a lot of responsibility there. And so they want to maintain that relationship. And so they try hard to do that. It's the other people that go in Melanie's file that she keeps in Kentucky that cause all the problems, it seems. But I don't have a good, but I guess I have a question, and maybe Mark or Tyler or somebody can answer this. In this discussion we're having this summer and fall, we're thinking, should public bodies be required or have, even as a best practice, that they keep a list of all of the requests that they get, who it was for, how long it took, what did they charge them, and etc. Should there be, so because we don't have any really hard data on how many requests each public body gets every year. And I don't know that that would be that hard to create or keep track of. So when we have these clashes at the legislature about that we should have some data that we jointly work with. That goes to your question, Steve, how many are media and how many are not? I don't know, but I don't know that public bodies keep track of that either. And maybe they should on a statewide basis, so we could really see in an empirical way, what is the burden and what is the cost recovery, and what, I mean, let's look at it in a mathematical way. We're also looking this summer and fall at records retention policies, because I think some of those, we may be trying to put some of those records retention policies of public bodies on a more forward basis. Usually it's something buried in your accounting office. But maybe the public ought to know, here are the kinds of records we have, and here's how long we keep those records. And that way, if I ask for 25 years worth of X, I'm sorry, you know, I only have 3 years worth. Okay, that's all we keep. I mean, I don't know why records retention has to be a secret on a broader level. I would hope that we could come to a better understanding and work that out. That would go, I think, hand in hand with keeping track of records requests, because then you could tell which requests came in that were, you had posted online, here's what records we keep and here's how long we keep them. And we had 70 people ask for records that we already told them we had destroyed 5 years ago. So some sort of empirical evidence, I think, would help us a lot.
One more question from Emily, and I think this arises from, Mark, your example or the state law provision that says you can't be sued if you've proactively put your records online. But I think the same question could be asked of Oklahoma. Is there any language in the law that states the format that records should be provided online in order to meet the standard as making it accessible? For example, databases are much more accessible in terms of easily disseminating information than PDFs.
What our Attorney General has said is that if you have records in an electronic format, you must give them in that kind of form, in the format in which you give them. You are not required to go out and save them in a format that is desired by the requester. The requester has no ability to say, I need that in Microsoft Excel, please. And you don't use Excel. You do not have to go buy a copy of Excel, convert it to Excel, and give it to the requester. You only have to provide it in the format in which you have it electronically. But if you have it in an electronic format, you have to provide it that way. One problem we've experienced in our law that says that public bodies can protect the integrity of their records is that they would take an Excel spreadsheet, which is easy to use and manipulate, and they will convert it all and save it to a PDF and give it to you, which makes it completely unusable in its original format, but they are protecting the integrity of their records by converting it to something that you can't change. That's, in our view, kind of a bastardization of the desires when we put that language in there to protect the public body from not having to go out and buy software because somebody else wanted it in another format. You've got to remember, when we were doing this, Lotus 123 was a big deal. All right. That's when, all right. I'm sorry for those of you that were not born when Lotus 123 was a big deal, but and you know that was all fairly new, desktop publishing and so forth. So it was all magnetic tape, okay, magnetic disc back then. So anyway, we felt like we've been a little bit abused by something we put in to let them protect the integrity of their records. They've taken electronic records, converted them to another kind of electronic record to make them less usable, and we're going to have to work through that this summer and fall. Just a word of warning, if that answers Emily's question.
Melanie, does Kentucky have any provision, or how does it treat electronic media, and what format it has to be disclosed in?
The law in Kentucky doesn't require any conversion from the format that exists with the agency. So, for example, we have records that are contained within our database, and so if somebody wants information from that, you know, we may print that out in hard copy. What we'll probably do is just make a PDF of the actual report. There's, you know, if an individual, so if a non-commercial entity requests a change, then we are not likely to do that. If we were to receive a request from a commercial entity, we would consider doing that, but we would charge them the cost of that conversion. If it were available, if it were something that we could do. Sometimes we've answered open records requests by taking information and putting it into an Excel spreadsheet, just because that's the easiest way to do it. But if a requester wanted an Excel and it was in a different format, and it was a commercial requester, we might charge for that. I'll be honest, we probably wouldn't. We would just put it in an Excel spreadsheet and send it. If it's something we have available, I think the law only requires that we provide it in the format that we have.
And I think that was intended to be a protection for the public bodies. And we felt like that was a good protection, or these abusers would come in. So yeah, we have that same language.
I can tell you that the integrity of the record argument has definitely been employed in Oregon with me. And it does seem a little bit odd that sharing an Excel spreadsheet with me will allow me to, you know, disrupt a government body's record keeping. But little editorial aside there. We have about 15 minutes left, and I want to make sure, Mark, that you get to make all the points that you think are most important. So
one question you asked me, Steve, was about how do you define news media? And that's becoming ever more complicated. When Julian Assange says he's a journalist, we're not sure what to do with that. In Oklahoma, we're still a little old school in that regard. The only real definition of news media is over in our SHIELD law. And I don't know if Oregon has a SHIELD law that allows you to protect some of your records from subpoena and so forth. And that kind of defines a little bit of what news media is. And so there have been a lot of states have SHIELD laws. So sometimes that is used. If you have to find a definition of a journalist, that's where you would look. But otherwise, it's pretty ill-defined. I do find on a practical level, no offense, journalists, but very few people are wanting to impersonate the media these days. So we might want to impersonate other people. Okay. But we really don't have a good answer for that. How do you protect someone's claiming their news media? But they would point to the SHIELD law, ask them for their identification, who do you work for, etc. But at the local level, they generally know exactly who they are and who they aren't. That's about it. I mean, it's just a fundamental. It's just a fundamental function of government here that you have somebody there that's to get these records and get them to you. What they can charge and search fees from commercial purposes are all things that are kind of worked out on a case-by-case basis. But I appreciate what you're doing, and we're doing the same thing. We don't have a formal group like you, but we'll be doing it this summer and fall with the Association of County Commissioners of Oklahoma and the law enforcement and everybody. Attorney General's office and so forth. We just get together and try and hash it out.
Thanks, Mark. Todd, do you have a question?
I do. Thank you. Thank you, Mark. I'm just curious. In Oregon, there's been discussions about how you define media here as well. And in my opinion, as the public records advocate, I honestly think it's a little bit of a distraction because the actual standard in the law is if a requester can demonstrate that there's a public interest in either overcoming fees or overcoming an exemption to disclosure, then they might be entitled to records or fee waivers or reductions that other requesters wouldn't be. And given the sort of parameters that have been defined through not statutory law, but case law, it's members of the media or those who are acting more like what we consider traditional media who can most often sort of meet those requirements. And so in my trainings to public bodies and actually even members of the public in the media, I advise that they focus more on, can this individual, regardless of sort of where they're coming from, meet this criteria that's not black and white, but sort of guides us, like, what's their ability to distribute this information, for instance, is kind of key to determining if there's a public interest and if they meet it. And so do you feel like, in your experience, it's worth trying to define who is the media, or can reform be focused more on an individual requester's ability to get out the information in a way that we consider to be in the public interest, regardless of like what title they're putting on themselves?
I don't necessarily know that it's in the interest to define it. When Steve sent me the list, it was just one of the questions he asked, and so I thought I'd try and answer it. That's about the only way we do it. But I mean, if you're in Oklahoma, if you're in the media, or it's in the public interest, or you're a taxpayer trying to find out where they're performing their duty. I mean, if you can't meet one of those standards, something's wrong. So it doesn't necessarily, but at the time we were doing it, we just felt like, somebody's going to look at the news media and say, well, you guys are corporations, your commercial purposes, you pay all of these fees. And we said, well, we were talking about journalism, and we thought that really needed to be defined, or at least be one of the things that was mentioned, that in the public interest or a taxpayer seeking to determine. So we went ahead and named ourselves back when we were doing this in 1987, when we had to come back in and define it. So we did it just so we could not necessarily be named a commercial purpose and have to pay all of your attorney's fees and so forth. So for public bodies.
Mark.
Yes, sir.
Oh, sorry, Mark Landauer.
Mark Landauer. Yes, I see.
Yeah, no, I wanted to respond a little bit to Todd there, just because, I've had an interest in defining media in the past simply because proposals coming forward would have automatically granted the media discounts or fee waivers or complete, exemptions from having to pay. And I mean, I've said it before. I generally think that when the media is asking for public records, it's in the they're doing it on behalf of the public, because I do see their role somewhat as being a watchdog to some extent. And so, Todd, I agree with you that if we could crack the public interest nut, we could dispense of the media definition, but at the same time, if you're going to automatically grant a fee reduction for the media, we need to know who the media is. And so that's where I see this tension, because determining public interest right now is like a triple bank shot with being blindfolded to some extent. Whereas having a clear definition of the media is pretty black and white, despite the fact that we could all debate whether or not a blogger is a member of the media or not. So I agree with you that if there was a way to crack that public interest nut, we could dispense with the definition of media. And that may be the approach that we want to take. I don't know. I haven't made any decisions, but that's where I see the tension. And I agree with you to some extent but it depends on, you know, what it is the end result is and what you need in order to actually implement that on the ground. I think I've made my point. So I'll just leave it at that. Thank you.
Hopefully I'm not abusing my my seat as moderator, but I had one response to that, Mark, and that is I'm interested in the fact that in the federal government and in these two states, you know, the feds, 3% of our requests are news media. These two states, less than 10%. All of these places have carve-outs for news media or for basically everybody, and yet it has not led to a proliferation of, you know, bogus media requests. Just that's my take on it. I mean, like, I definitely hear you. It seems like it's ripe for abuse, but it doesn't seem like there's a record of abuse. You know, you're muted.
I would agree with you on that, Steve. I mean, I don't think that we have seen a record or a demonstration of abuse, but I do feel as though there's a vacuum being created for that to potentially be used and weaponized, right? And that's what I really, that's what I fear, is that without some way to deal with the problematic requesters, the frequent flyers, and I didn't say this, somebody else did, the unhinged and otherwise.
Nuts.
I didn't say it, but I appreciate your comment, Mr. Thomas. I just feel strongly that I'm committed to finding the balance, right? But the balance is important, particularly, I think, for some of these smaller resourced local governments who just do not have the ability to, or necessarily the expertise. I want to make it real easy for everybody. And under previous, you know, proposals, particularly in 2021, I just couldn't get there without some more clarity. And I think you can appreciate that. I'm committed to finding this balance, though, because I do recognize that media is not the problem, or at least I believe they are not the problem. But there are problems out there that we have to be cognizant of. And if you're just going to say anybody from the media gets a free, you know, a free pass, I just feel that those problematic individuals are going to adopt, well, I'm with the media, okay? Yeah. And I feel that's a problem. And again, I'm committed to finding that balance.
So I'm going to turn to Tyler and Todd next, but I think you're right, Mark. What you have identified is like dealing. It sounds like we're talking about a subset of the fringe. You know, those who might seek to use the news media carve out as an out. And I don't know where I stand on this, but I think, you know, Kentucky has offered us an example now of an alternative approach rather than defining news media to look at the extreme, you know, to look at the harassers. I think that's worth looking at. We've also talked about Connecticut, I think, that has a similar kind of process. So those are worth exploring further.
If
okay, I think
could just add, I just sent you some resources by email, which included some AG opinions interpreting that specific section that we talked about, the undue burden section that's included in Kentucky's law. There is I also included the reference for a case with the Courier Journal, Louisville's newspaper, and the Kentucky State Police, in which the Kentucky State Police attempted to use that section against them as a media, and it actually went from the AG to the Franklin Circuit Court to our Intermediate Court of Appeals, the Commonwealth of Kentucky Court of Appeals. And so there's a cite to that in there as well. So I included our entire statute. If there's more that I can get you, let me know. I didn't mean to interrupt, but I just want to let you know I'd sent that.
That's terrific. Thank you so much, Melanie. I really appreciate it. I think Tyler was first, so do you want to go?
Sure, and I'll be quick. You know, here's my overarching observation over this meeting of our group and last meeting of the group is we just don't know who's making. We don't have enough data. We keep coming back to anecdotes, and so we have you know, the question that would spring to mind if, okay, let's accept 3% of the requests are coming from media. How long does it take to compile those requests? Are they functionally different from a private citizen making a request? And so I think I've just been mulling this over ever since our last meeting, which is just how can we come up with a way that is not extremely onerous on public bodies, but a way that is, you know, simple at a glance where we could get a snapshot of meaningful data so that we could help define our problem a little bit more, because otherwise we retreat to, you know, these kind of boogeyman ideas of somebody might do this or somebody might do that. You know, I'm more interested in, could we spend some time exploring our known universe? And then based on that, we can move forward incrementally, you know, where we have problems or where we might not, but without knowing, you know, who's making the requests, how long does it take to compile them? Are you charging fees or not? It's so difficult to move forward.
Todd.
Thank you. Steve, first of all, I just want to remind you, send me what Melanie sent to you, please, and I'll have it posted on the website for today's meeting. I just don't want to forget to say that. And then just secondly, I just want to say personally, I'm just a little bit uncomfortable with some of the language we're using to refer to certain types of requesters for a variety of reasons, including that, you know, people exist on a spectrum, including when it comes to mental abilities, and regardless of how we perceive them, if they're requesting their government provide records, clearly this is a matter of great importance to them. And I just think, you know, just in my service to the public, I try to keep that in mind. Now, certainly that doesn't mean any of us need to endure abusive, threatening, dangerous, or any other kinds of harassing behavior to do our work. I will say I'm glad, though, that Oregon does not have a vexatious requester provision in this law, in part because I think there are already existing ways in which those types of requests can be dealt with. And frankly, they tend to collapse under their own weight, in part because they are so large. What's being asked for can be unreasonable, or there's often an unwillingness to work with the government to narrow the request. And so just personally, you know, this is not language that I would tend to use in these situations. And I just wanted to share that with the group out of respect to our constituents. Thank you.
Thanks, Todd. Yeah, personally, I would agree. I think we do need to be mindful of how we characterize groups of people and behaviors. And so I guess we're coming up on the hour, and does anybody have any? I guess maybe I should hand it back over to Emily or maybe Todd in her stead to wrap up the subcommittee's business.
Sure. Thanks, Steve. I think Emily is still not able to, she can hear us, but she can't communicate. So I'll just wrap us up. Again, thank you to all of our speakers. This was incredibly informative and allows us to continue sort of building towards this ultimate conclusion of hopefully drafting useful legislation that will benefit everyone here in Oregon, and perhaps once again make us a model for the rest of the country. I very much agree with Mark's statement that I think all of us within every state is sort of working or aspiring to having sort of the best type of public records law that we can. And, you know, Oregon's led the way before, and I look forward to the opportunity to give us the chance to maybe lead the way again, learning from our peers in other states while we do it. But before we go, I just want to give the update from Emily about her work with LPRO, which is that they are tentatively scheduled to testify on May 13th, at which point we will get updates from them about all the fabulous research they've done for us that will again continue to grow our knowledge. So once again, thank you to everyone for your time today. We do have a public comment period left on the agenda. I know, Steve, you left it open to anyone from the public that wanted to address our speakers, but given our final moments here, I'll open up the floor to anyone left on the call that wants to address the committee about what they've heard today. I'd ask that they please limit their remarks to a couple minutes and focus on today's presentation. Okay. Oh, Tyler, you got your hand up. Go ahead, please.
Yes, sorry, I'm not a member of the public, but I just wanted to share with the group. I'm going to be heading out on paternity leave for a couple of months. Very excited for that. But my colleague Mallory Roberts from the Association of Oregon Counties plans to join these meetings just as a member of the public, although she is an expert on all things counties, and feel free to ask her questions. So thank you all for the past few months. I've really enjoyed it, and I really look forward to jumping back into this conversation after a couple of months.
Well, thank you,
Good
Tyler.
luck, Tyler.
Congratulations.
Congratulations.
My one tip, grab all the sleep you can whenever you can. All right. Do I have a motion from someone to adjourn this meeting?
So moved.
Second. Thank you. Everyone have a great weekend.
Thank you, everyone.
Take care.
Thank you for having me.